Welcome back, everyone. After our short break, we have Ledge Council with us. So thanks for being in our committee. I don't think we've ever had you in our committee before, so we're really thrilled that you're here. I know you have some slides to share, so maybe while you're bringing those up, Commissioner Sampson sort of, when we were doing our last testimony, had slightly kind of raised his hand a little bit, and I wanted to give him just a moment to speak while you're bringing up your slides.
Sure. Ty Sampson, Commissioner at DFR. Then the discussion about whether the richness of benefits drives utilization. That's an actuarial impact that's measurable and has been measured, called induced utilization. So when you compare two different healthcare plans or benefit plans and you want to set them as equal to understand what's going on, you make many adjustments. And I know, knowing what the small group induced utilization benefit average is and what the VHI group is, there is a difference of about $70 per member per month. So, and that's just actuarial, say fact, but actuarial math. So that's about $70 a month, and it's about an 8% difference in the claims per member per month when normalized for all the things: age, induced utilization, etc.
Thank you. Thank you. Thanks, Sophie.
So good morning, Sophie Zadatny for the Office of Legislative Counsel. And what I'm going to do, and I've given you a handout, and these slides are also on your website. So I was just going to run swiftly through the Commission on Public School Employee Health Benefits. And again, this is a presentation that will seem familiar to some because I've done this for some of the education committees as well periodically when they have questions. So again, this is just really reinforcing some of the history that you've already heard. So again, prior to 1993, direct bargaining happened at the local school district level. So that was all negotiated, and there are many different union contracts across the state at the local level. And then in the 1990s, VHI was created. And then in 2017, there was a provision to penalize school districts whose employees did not pay at least 20% of the premiums, and those districts that did not limit the amount of the district's assistance towards the employees' out-of-pocket costs. Moving this thing around on my screen, it's really annoying. All right. So in Act 11 in 2018, that is when this commission was created, and it's in subchapter 61 of Title 16, and it creates the statewide process for health insurance. So what it did was it took health insurance as a subject of bargaining out of the Labor Relations for Teachers and Administrators Act. So normally health insurance is something that is bargained, across the bargaining table, as you've heard. And so it removed certain elements of that. So it removed healthcare benefits and coverage, health reimbursement arrangements, health savings accounts as subjects for bargaining at the local level. And then it kept vision and dental benefits continue to be negotiated at the local level. And then VHI, as you've heard, they work with Blue Cross and Blue Shield. They develop the health plans. The plans are reviewed by DFR. And then the commission determines the cost sharing and eligibility requirements. The commission is made up of 10 members. And again, it's a partisan. They serve in a partisan capacity. It's not a neutral commission. So they're there advocating for their respective sides. So 5 representatives of school employees, 5 representatives of school employers, and the statute provides that appointees shall have an understanding of healthcare and employer-employee relations.
What is the AFSCME?
Right, so that's one of the unions. So four of the representatives are appointed by the NEA, representing the teachers. And then the way the statute is written, the second largest union also has a representative on the commission. And so AFSCME represents some of the school, the other workers in the school system. All right, and the commission is chaired jointly by 1 school employee representative and 1 school employer representative. They can be removed by the appointing authority without cause. All decisions require the votes of a majority of the school employee commissioners and a majority of the school employer commissioners. And then they have, compensation. And then these are the things that the commission currently determines. So again, if you make what's proposed in the bill, you'd probably be narrowing some of the things that they would be bargaining over. So currently, these are the issues that the commission negotiates over. The percentage of premium paid by the employer and the employee for individual two-person parent-child and family plans, the amount of an employee's out-of-pocket expenses, and then who's going to be responsible for those, whether to have a health reimbursement account, a health savings account, or both, who bears first dollar responsibility for out-of-pocket expenses, and if you're using an HRA and whether the HRA balance rolls over from year to year, and then a grievance process for any disputes regarding health employee benefits. So contracts will be for not less than 2 years in duration. The dates that are in here are the dates for the upcoming negotiation. So as you heard, there were 2 negotiations, and then most recently, there's been a decision to roll over the existing agreement. And so that's happened twice. So the current agreement expires at the end of 2028, and the new agreement will go into effect January 1 of 2029. But it's a long negotiation process and a very structured negotiation process. So right now, again, looking ahead, these are the dates that would apply. So information requests, so again, each side asking for information from the other side. Those must be made by October 1 of this year. And then the negotiations begin, and then responses must be provided before February of 2027. The negotiations themselves begin April 1st, and the current contract expires 12/31/28. So the parties in anticipation, so again, there's all these dispute resolution mechanisms in here. So the parties select a fact finder at the beginning of the process. So they kind of, in anticipation that they're not going to be able to resolve it amongst themselves, they go ahead and agree on a fact finder at the beginning of the process. And then the commissioners are required to meet at reasonable times and negotiate in good faith. So dispute resolution. So, and this is not unusual, and I can touch on, we have 7 labor relations statutes in the state, and I can give you a quick update on those as well. But essentially, the goal of with collective bargaining for state, so again, the National Labor Relations Board, National Labor Relations Act covers private employers, employers engaged in interstate commerce, and then the states cover public employees and certain other groups. So again, these are all creatures of state statute. We have 7 labor relations statutes here in Vermont, and the dispute resolution mechanisms are designed to push employees and employers to reach agreement without, hopefully to avoid strikes. So strikes are permitted under the Teachers Labor Relations Act, but generally for like the State Employee Labor Relations Act, some of the others, strikes are prohibited. And the goal of these dispute resolution mechanisms are to get the parties to reach agreement or to push them as close to agreement as possible before you invite mutual third parties to come in and help them move the process along. So if the parties are unable to reach agreement by August 1st, any matters remaining in dispute shall go to fact finding. So again, the parties may agree on, if there are 10 issues, they may agree on 8 of them and then go to fact finding on 2 of them. If the parties are unable to agree on a fact finder, then the American Arbitration Association would appoint the fact finder. The fact finder is, again, neutral. Their report is non-binding. They will attempt to find agreement between the 2 parties, and their report is due by September 15th. And then if they can't reach agreement within 30 days of receiving the fact finder's report, then they would move to arbitration. And then there are 3 different options here. So the commissioners can either mutually agree on an arbitrator, or if they can't do that, then either the Vermont Labor Relations Board or an arbitration panel would decide the remaining matters in dispute. And so again, this just runs through, if you have a panel, each side picks one, and then the third one is appointed by the American Arbitration Association. And then the parties submit their last best offer to whoever that final decision maker is prior to the hearing, and the hearing has to be held by November 15th. So last best offer, and this is an issue, this is why I've been in some of the education committees. Last best offer is a mechanism that's used to get the parties to figure out what is most important to them. So again, last best offer is designed to get the parties as close as possible. So if you ask each party to do their last best offer, they're going to pick, what can we live with? Not what would we like, but what could we live with? And then put that into their last best offer. And then typically last best offer operates with the final decision maker picking one or other of the last best offers. So it incentivizes parties to move to the middle. You don't want to be unreasonable in some aspect, because then the other party's last best offer will get selected. So that's a mechanism that we have under a number of the labor relations statutes. And that's what is in currently for the commission. So again, whoever that final decision maker is would select one of the last best offers in its entirety without amendment. And then there are a list of factors that are included in the statute of what that decision maker would be looking at. So interests and welfare of the public, financial ability of the ed fund and school districts to pay the costs of the healthcare benefits and coverage, comparisons of healthcare benefits with similarly situated public and private sector employees in Vermont, the cost of living, prior and existing healthcare benefits and coverage for school employees. And then the decision maker, whether it's the Vermont Labor Relations Board, arbitrator, or a panel, they would issue a final binding written decision within 30 days of the hearing. There's no right to strike if people don't like the outcome, and there's no requirement that the final decision be ratified. So that is the decision at that point. And I just added that in because under the Labor Relations and Teachers Administration Act, there is a right to strike. So I just wanted to highlight that because under the commission and the benefits, there is not a right to strike.
Can I just ask, back one slide, the dispute resolution for last best offer. There is, it says comparisons of health benefits with similarly situated public and private sector employees. That seems a lot in ways of saying basically the language that is in version 1.1 of 190.
The language that you've got in version 1.1 of 190 on page 9, I mean, that's much more explicit. I mean, that's sort of that's saying before they go into these negotiations, before they start discussing what they're going to do, is, it's putting some specific guidance on what that will be.
So it's just being a little bit more specific.
Right. And both parties would then know going in that the actuarial value of any health benefit plan offered to school employees, et cetera, would have to comport with the language that you have in this bill.
I'm trying to read the comparisons of healthcare benefits. Is that talking about like the financial benefits, or is it talking about like the benefits that it offers, plan design, things like what does it cover, what it doesn't cover? I'm trying to figure out what healthcare benefits mean.
Yeah, and I have not been involved in these negotiations, so I don't know exactly, and some of the folks in the room may be able to tell you on that. Often in bargaining, it can be at a very high level, in this bargaining agreement, people pay 25% of the premium and, they have this kind of HRA or whatever. So it can be at a very high level, but it may be, given the testimony you already heard this morning, with the number of witnesses and experts that were involved in these negotiations, it may be that they get into a much more granular view in these negotiations. I just don't know on the ground what that's looked like.
Leslie? Oh, yeah.
Good question. So this is vis-a-vis these two parties, but who in the first instance negotiates with the administrator? The Blue Cross and Blue Shield, what the premiums might be, all those particulars of the health plan itself. Is it this group or something?
So my understanding is VHI works with Blue Cross Blue Shield and then provides plans to the commission. So there's a multi-step process. Then the commission and the folks on the commission are not working directly with Blue Cross Blue Shield over the plan design. The plan design is through VHI.
Thank you.
very helpful. We actually have a process that we set up. 2017, were you here, Lauren? You were, okay. Any other questions for Sophie?
It's the other piece. There was another presentation that's on your website. And again, we don't need to go through it, but I just wanted to flag that obviously for the teachers, the Labor Relations and Teachers and Administrators Act, there's language that specifically pulls out healthcare bargaining from, the subjects of bargaining when they're negotiating, at the local level. Under the State Employee Labor Relations Act, health insurance is typically bargained between the parties. Under the Municipal Employee Labor Relations Act, health insurance would be negotiated by the parties, except for school employees that aren't teachers. As you heard, they're covered by the Municipal Employee Labor Relations Act. And then under the Judiciary Employee Labor Relations Act, that would also be a subject for bargaining. My point simply being that the legislature can sort of decide what can be subjects for bargaining and what are not. So that was really the point of the other presentation that was included.
That's actually.
Chair, I was just gonna say, so that's where we can set that.
Right,
condition.
you have done already, like that's what you did.
So we're allowed to do that. in the,
2018, right, by pulling it
Chair?
out.
Brian, I hear you. Let me get to Wendy.
Oh,
You're ahead.
okay, thank you.
Okay, no, go ahead, Brian. You go first.
Yeah, there's just no other way to tell you, and
I know.
I'm driving too, so I'm trying to be careful. I just have a question for this witness because I'm not sure if there's another person to ask. I'm understanding, I appreciate the greater detail about how the state has set guidelines around bargaining for public workers with the state. At what point I guess I have two questions. One is, does the state do that for private workers, or does the state only set these kind of guidelines around negotiations for these public workers?
So private employers and private employees of private employers are covered by the National Labor Relations Act. So that's all determined at the federal level, not at the state level.
And so, the state of Vermont, as an employer, has the power to set the terms of the negotiations with the employees. Then,
right? I mean, it's the state has the power to to create statutes, amend statutes, whatever, for any group of employees that are not covered by the National Labor Relations Act.
okay, yeah.
If someone's covered by the National Labor Relations Act, then, then the state cannot, that would be preempted. But the state can for any workers that are not covered by the National Labor Relations Act. They can.
Are the only people who are not covered state workers and public workers and like teachers, or are there other classes of workers in Vermont that are not covered by the Federal Labor Relations Act?
Yeah, so there's like agricultural workers are not covered. They're explicitly excluded from the National Labor Relations Act. They're also currently explicitly excluded from the State Labor Relations Act. So we have this act from the 1960s that really is almost never used, but it's basically to fill in anyone that's not covered by the National Labor Relations Act. But once that was passed, the state in the 60s and 70s moved forward with these, and more recently has moved forward with these other specific labor relations statutes. So for example, domestic workers that worked, there were 5 or more domestic workers. They were previously excluded from coverage both at the national level and at the state level. And there was a change made either last session or the previous session that removed them as an exemption from the State Labor Relations Act. So there are other groups of employees that are currently not covered either at the national level or at the state level.
Thank you. I appreciate you bringing up some of our recent actions and tying it all together. I'm not going to ask more questions because we're on a time crunch, but I will say that we can come back to later that this concern I have, which is I feel like as the employer, I guess the question I would have is at what point are we overusing our power as the employer to create an unfair condition for our state and public workers that other workers don't face? And we can talk about that later. Thank you.
My sister follow up, like when anyone is in the
throes of bargaining, is there any point in which we can't change what we're doing for the health benefits? Like,
I mean, it's,
you're negotiating health benefits and we're making changes, like, are we stepping on toes at any point during the negotiations?
well, I mean, you'd be setting the changes that you would be making if you were to move forward with this version would impact the negotiations. But again, the parties would then negotiate knowing these things are in state statute. And again, that it's not unusual. I mean, the General Assembly passes employment laws all the time that impact employees that then just generally when you're bargaining, you then have to take those into account. So the law can change that could impact a collective bargaining agreement. And one example was things like no smoking in workplaces.
Hmm.
So, and I just have personal knowledge of that as being an issue that came up in a previous position. And so then that's something that you do what's called impact bargaining, where, you know, the state law might change. And so you need to adjust at the, you know, in your particular workplace, but it's contrary to the collective bargaining agreement. The parties then would do what's called impact bargaining over that change. Like, okay, how are we going to implement it? What's the date we're going to implement it? Who's going to be impacted? What are the parameters? You know, so, you know, collective bargaining agreements are between the two parties, but if something comes up, a court decision could be issued that says, you know, you can't do X, and yet you've got a collective bargaining agreement that says we do X. So you would then do impact bargaining over how are we going to adjust the collective bargaining agreement to respond to that change that's come down from the court or from the General Assembly. And again, if the parties can't agree on how to handle that particular change, you would go through that dispute resolution mechanism. You'd go to, not in this particular, under the commission, but in other bargaining statute, other state statutes, you go to mediation, then you go to fact finding, then you go to either, you know, arbitration, binding arbitration, or to the Vermont Labor Relations Board. So you would do that on impact bargaining as well.
So those seem small compared to, you're talking about the big ticket items in collective bargaining would be what people are making for income and what people are paying for their health insurance. Those seems to be the big ticket items that seem immovable when you're negotiating. I guess like this would impact that significantly.
It would. And I think as you heard this morning, when the legislature made the change with Act 11, there was huge disparity across the state, for example, on how much individual teachers in different districts were paying. So that was a major impact to say we're now going to do it as a statewide approach and not on an individual district by district approach. And so then there would have to be changes made, you know, at the local level, like, okay, well, someone went from paying only 12% of a premium, they now have to pay a higher percentage. Is there going to be, again, what's the impact of that? Do we then increase their salaries? Because again, as the testimony was this morning, that, and that's not unusual, but when you're negotiating, often the value of the benefits and the salary, those are two pieces, right, that you're negotiating over. You know, do you want more in wages? Do you want more in benefits? And that's something that the employer and the employees are working on across the bargaining.
That became a statewide thing.
Right.
And I can definitely understand how that would have impacted it. So then it becomes a new circulatory thing. I'm just worried that, and especially when the NEA was in here, that's a long negotiation process. They're starting now for something that's going to affect 2028. It seems like a very long
2029.
2029.
It's because of the school budget, and it's just the process, right, for the school budget to get through. So they need to know that. I mean, that's unusual. That's not the same for the state employees or judiciary employees or whatever. I mean, that's sort of unique to this because of the local budgets.
So it seems like they're going to start negotiating, and then we're going to say, no, that's not what you're going to get. You're going to get this one. I'm just worried about the negotiations and the contracts and things like that that's going to come out of this. And is it legal to tell them it's different after they contractors after they?
Well, as I understand it, the goal here would be if this were to pass, that would be language that both parties, as they go into the upcoming negotiation, would have. They would know that going into the negotiation, that these are the parameters now that we will be negotiating around.
Okay.
We're not changing their current negotiated,
Just going forward.
just
New
going
contract.
forward.
Yeah, I'm just seeing like this timeline of like, they're already like negotiating.
Not yet.
Not yet.
Okay.
Not till April of next year. They just start the process of requesting discovery, et cetera, the sort of preliminary work that goes into negotiating their
So
stuff.
if we pass this, what is the time, if NEA or the IHIP was in here, when would that?
It was on one of the slides. I can pull it
Okay.
up again.
I think this section would be on passage, which would mean that they would have that information
Okay,
when they begin
that's what I
their,
wanted to know.
yeah.
Okay, thank you.
Thank you so much, Sophie. Really appreciate you coming in.
You're very welcome.
Nice to have you. Okay, we have. Oh. Sue, and Sue, I apologize if you could pronounce your last.
Yes, Siglowski.
Siglowski. Thank you. Thanks for coming in again.
Thank you very much for having me in to testify again. I'm Sue Siglowski. I'm the Executive Director for the Vermont School Boards Association. And my testimony will be very brief, which will help you make up a little bit of time, I think. First, I want to be clear that the VSBA supports the changes in draft 1.1 that add VHI to the move toward reference-based pricing. We also greatly appreciate the newly reworked Section 4 covering cost containment and health benefit plans for school employees. That section puts guardrails on the actuarial value of any health benefit plan offered to school employees, inclusive of the HRA, and as you've been discussing, provides equity with the highest actuarial value plan offered through the Vermont Health Benefit Exchange. We also appreciate the requirement in Section 4 that participating employees shall bear first dollar responsibility. Currently, the employers, taxpayers have first dollar responsibility, which means that the employees pay no deductible. With the addition of the new language in Section 4, the legislature is taking a meaningful step to address health benefits as a cost driver in property taxes. In conclusion, we urge you to support draft 1.1 of S190. It is an important step in limiting the extraordinary growth in health benefits costs paid by Vermont taxpayers. And as you will hear from Attorney Joe McNeil, who's testifying directly after me, such a decision is both legally permissible and a desirable guardrail the legislature can establish in the public interest. Thank you for the opportunity to testify on this critical issue.
Any questions for Sue? Thank you, and thank you for the brevity and the clarity. That was because we are running out of time. And Joe? Oh. Hi, Mr. McNeil. How are you?
I'm very good. How are you?
Good.
Good morning, Madam Chair, and good morning, committee members. My name is Joe McNeil. I'm an attorney in Burlington with McNeil, Leddy & Sheehan. And by way of background, I have been involved in labor relations and collective bargaining since essentially the inception of public sector collective bargaining in the state of Vermont. I represent a number of school districts currently, and for the last several cycles, I have represented the state of Vermont in its bargaining with VSEA and the Vermont judiciary in its bargaining with VSEA's judiciary unit. We also do the home healthcare workers and a number of municipalities and school districts. So I'm quite, and I am counsel to the employer commissioners with respect to the Healthcare Commission for educational employees that's being spoken of today. So I come with a, fortunately or unfortunately, a fair amount of background in collective bargaining and labor relations. In answer to one question that Brian Chena raised just a few minutes ago, Sophie covered it pretty well, but there is also a statute called the State Labor Relations Act, and that covers a limited number of employers within the state that are not involved in interstate commerce. In order to be covered by the National Labor Relations Board, there needs to be a bit of, it's a fairly broad test, but there needs to be a bit of interstate commerce involvement. And if there isn't, then we have a similar statute in Vermont for private sector employees. I want to say that we believe that the bill now before you in its current format is both legal, very clearly legal, and if you believe it's appropriate, it's well within your prerogative to achieve. The General Assembly regularly articulates standards which one way or another impact how collective bargaining is carried out. And this ultimate oversight is neither impermissible nor inappropriate where the legislature believes that specified guardrails must be established for the protection of the public interest. That's why you're elected, and that is your penultimate charge. And on the other side of the ledger, for example, just last year, the General Assembly passed H 461, which became Act 32. This particular measure expanded the opportunity for both paid and unpaid leave for Vermont's employees and will subsequently govern the terms and conditions of collective bargaining agreements that are negotiated within the state. It added a category called safe leave and amplified personal leave benefits. Did doing so impact how parties would collectively bargain in the future? Yes, it did. For instance, the measure made impermissible what was then a current provision in the contracts between the state and VSEA, which connected the utilization of personal leave to the utilization of sick leave. And the statute made clear that that would no longer be allowed. And as a result, in this round of collective bargaining, the parties adjusted to meet the guardrails that had been established by the legislature in last year's session. Even more fundamentally, if I may, the United States Fair Labor Standards Act requires that overtime compensation be paid for all hours worked over 40 hours per week. Collective bargaining agreements cannot be to the contrary of that statute. That statute was created because the Congress believed that this type of guardrail was necessary in order to protect the public interest and the interest of employees. So the General Assembly and the Congress passed these laws under the belief that the choices are in the public's best interest. For the same reason, this body may decide that the actuarial value of the healthcare plan for educational employees should not be in excess of the actuarial value of the highest valued plan subject to regulation. This decision would be made in order to limit the extraordinary growth of the dollars that Vermont school districts and Vermont taxpayers are paying for health insurance. Such a decision would be both legally permissible and arguably desirable guardrail established to govern future negotiations. The same would be true for the proposed standard that school district employees, rather than employers and their taxpayers, be responsible for paying the first dollar obligations for health savings accounts and health reimbursement arrangements. Interestingly enough, this employer first dollar standard was the original recommendation from the administration to the General Assembly, together with the 80-20 premium share that Sophie mentioned. At the time, statewide bargaining for healthcare benefits for educational employees was proposed to replace the district by district collective bargaining. With any change, there are advantages and disadvantages. I think time has taught us a lesson that one of the disadvantages of the statewide healthcare bargaining is that we no longer have the opportunity to play off salaries versus healthcare in the immediate bargaining framework, as healthcare is looked at independently and separately from the other bargaining. It's my view that in part because of that, the cost escalation has increased exponentially. In summary, there is no question in my mind that the General Assembly may legally enact the provisions of Section 4, and future collective bargaining will simply need to be consistent with the standards that are created. With that, I'm make myself available for any questions that you may have. I am knowledgeable about the bargaining history, structure, et cetera, for both healthcare and in general with regard to educational employees and public employees generally.
I just wanted to clarify the last point you were making, because I think I understood. Are you saying that when the bargaining for health benefits was separated out of the collective bargaining, that there ceased to become kind of the bargaining between, okay, you will pay you more, but you have to pay more for your insurance, or you're going to have to pay more for your insurance, but so that means that by separating them, they're no longer in sync with one another in the bargaining process?
I meant, yeah,
Or play
good
off of each
question.
other?
Madam Chair, good question. And I was pointing that out just as an illustration that with any change in statute, there are both benefits and limitations. The benefit of the statewide passage was the hope, as expressed at the time, that there would be some $70 million worth of savings on a statewide basis because of the 20% premium share and the first dollar obligations. Those did not come to pass. There are still benefits from statewide bargaining in that there is a real focus on healthcare. There is a focus on benefits. And a question that was asked earlier was, did the statutory language about benefits only go to the healthcare benefits themselves, or did they include cost? And the answer is both. The parties look at both as they are going through the process. But one of the things that turned out to be lost by the new statute, then new statute, was the ability on a school district by school district basis to get into the weeds on both healthcare and salary and work with both.
Thank you. Go ahead, Leslie, you have a question?
Not a question. I mean, I'm wondering if you could like give us some your testimony in a written form. Particularly the fact that this bill is legal, that was helpful to me because I don't understand a lot of this, but thank you.
I'd be
Thank
happy,
you.
I'd be happy to do that through Sue Siglowski, who has a copy.
Chair, I have a question.
Oh, yes, go ahead, Brian.
First, I just want to say hi to Joe because Joe is the lawyer for the Burlington School Board when I was on it. So hi, Joe.
Nice. Hi, Brian.
It's nice to hear from you again. And I just wanted to ask one question, which is, what I'm hearing is that what this amendment to the bill before us, or draft 1.1, I think it's called, right? What it does with bargaining is completely legal because the legislature has the power to change statute, and that there's nothing in our statute saying that as the employer we can't set guardrails around negotiations with public employees. So it's totally within our power. It's totally legal to do it, and that it's more of an ethical choice or a moral decision or a policy decision. It's not a legal thing. Would that be
Brian,
correct?
yes, you're absolutely right that it would be legal and within the parameters that the legislature can and very often does set. I'd hesitate to use the word moral or with regard to collective bargaining because there's aspects of it that sort of don't fit with that definition. But I would totally concur with you that as a matter of policy, if the legislature believes that this is in the best interest of the state and its taxpayers, it is well within your prerogative and advisable then to do so. As Sue Siglowski or others have pointed out, I mean, the result of our healthcare bargaining is that we now have a plan that is superior to any in the educational benefit realm with regard to being a platinum plus plan. And the expense roll-up is incredible. I could, if the committee wanted it this time or some other time, give examples from school districts as to the increasing cost of their health care, but I think you've probably already heard that testimony.
Thank you. I have one other quick question.
Go ahead.
Yeah, and it's that, and you might lose me because I'm in the mountains. I have to take a back road. If anyone's listening, don't come south on 89 right now. It's all shut down. So if it cuts out, I'm sorry, and you can just move on. But my last question was, if the state decided to create like a universal health care program, is there anything, it sounds like there's nothing prohibiting us from requiring the state and public workers to be in that, right? Because if we can control negotiations, we could also take something out of negotiations. We could just say to them, we're not going to negotiate healthcare. You're getting it with the same as everyone else through a universal system.
That's absolutely true, Representative Gina, and I'll give you an example. In state of Vermont employee negotiations, we do not negotiate the terms of the retirement system. The legislature has decided by previous legislation that the retirement benefits will be determined by a committee that looks at that benefit specifically. By contrast, in municipal negotiations and in other forms of negotiations, retirement often is a subject of direct negotiations. So yes, the legislature would have that authority.
Thank you.
Thank you. Thank you, Mr. McNeil. Really appreciate your expertise and experience on this. And thanks for joining us today. Okay.
Thank you.
And we still have 4 witnesses left. So I'm just gonna ask people to be as quick as possible because we cannot go into the lunch hour. unfortunately. And it's looking like we do not have any time after 4 today. Adam, you want to come on up?
Thank you for having me, Madam Chair and Committee, and thank you for your continued work on reference-based pricing. For the record, Adam Norton, Strategic Analyst, Vermont State Employees Association. I'm ecstatic that the committee and seemingly all the stakeholders are continuing the project of reference-based pricing that really began with the report supported by us and our colleagues at NEA, moving forward in that direction to have less exorbitant, hopefully, and more rationally based hospital costs. As it relates to Bill 1.1, draft 1.1, excuse me, of S190, VSEA would love to be included. Should the committee move forward with a pilot is currently drafted in 1.1, or should they decide to do everybody at once, which we've been advocating for this session? We would love to be included. Our premiums have increased 63% in the last 5 years. Our health plan is currently in deficit and in worse financial situation than VHI or Blue Cross for that matter. And it may also behoove the committee to know that these savings, 80% of which would go back to the state, as considering the 80-20 premium split that benefits us. In these tight fiscal times, we've had 60 layoffs in the last 10 months at AOT. And we're looking at a much difficult fiscal picture moving forward. Those savings, 40% of which go from state employee payroll, is 40% general fund. Those savings certainly, I think, would be welcomed by our budget writers if we were included. On section 4, and that's speaking of the reference-based pricing section in section 2, on section 4, VSEA has a few comments and a few misconceptions, I think, that we'd like to clear up. It is not unusual for public employees to have high actuarial value healthcare plans. In fact, in states where that's collective bargaining for public employees is legal, that is the norm. It has been the decision of public employees and their counterparts, their employers, through their collective bargaining over the last, started really in the 70s, public sector collective bargaining in the late 60s, to have higher actuarial value healthcare plans because we would like our members to be able to afford to use their healthcare. It would be unusual, to say the least, and unique in any of those collective bargaining states that I'm aware of to have collective bargaining conditioned in this way. And as a matter of principle, the VSEA is opposed to the conditioning of collective bargaining by the legislature. I also, and I can provide it to the committee because of all this discussion about utilization versus price and whether what's driving our healthcare costs, it's a really important discussion. And fortunately, we don't have to have a philosophical debate about it. The Kaiser Family Foundation has done great research on this, comparing our healthcare system to the Europeans. And not only do they have much better health outcomes and a much cheaper system, their utilization rates, whether it's doctor's visits, MRIs, hospital visits, duration of hospital visits, are all higher than ours. And based on those conclusions, you can see utilization isn't our problem. In fact, when it comes to primary care visits, it's the exact opposite. On average, they see primary care doctors per capita about twice as often as we do, and there's a big shortage, and that does drive our healthcare costs because people have to go to the ER or to get to see any medical attention because there's no primary care available. Anything else? Oh, finally, I just did this with the bargaining unit. I think Representative Taylor asked a very good question, and I just went through this with the collective bargaining group, not the state employees, a different unit represented by VSEA. If you increase, there can be unintended consequences if you increase people's healthcare contributions, whether it's in the form of out-of-pocket costs or premiums. And I just did this with a healthcare group, and we went through fact-finding, and the result was the employer had to make them whole. And that actually cost the employer more because the wages to make them whole are taxable. So the employer's paying FICA in addition to those wages, and they're paying retirement contributions on top of those wages. So the idea that section 4 will necessarily save money, it's more cost shifting than cost control. And school boards, with their own authority, could choose to use their savings another way. But there is a real risk. And if they were my members, I'd recommend them. You should go into bargaining and demand you're made whole. And if you're not, use your impasse procedures to the fullest extent. They have different impasse procedures than we do. They have industrial action as an option. I guess the last thing I'll say is somebody who is an expert witness for the healthcare bargaining that the teachers went through. Their impasse procedure for healthcare bargaining is very similar to ours, fact finding and then arbitration, last best offer at arbitration. The school boards lost because they made proposals that weren't grounded in reality and they tried to increase out-of-pocket costs by several $100% at once. That won't work in fact finding unless you have comparables to justify it. They did not. And so it seems to me that what they're doing here is trying to remedy their failure at bargaining, whereas they just had reasonable proposals. They might have had a chance of success, but they went for Hail Marys and they failed. Unless there's any questions.
Do state employees have any out-of-pocket costs?
Yes, we have 2 plans, Total Choice and Select Care. About 90% of the actives are on Select Care. They have copays and for Select Care, and then there's, a small drug deductible of $75 to $150, I believe. So they do.
Great. Any questions for Adam? Great. Thank you so much for coming in. We really appreciate it.
For having us.
Thank you, Adam. All right, Courtney. So in the interest of time,
I was asked.
how do you, version 1.1?
Yeah, I'll, Courtney Harness, Blue Cross and Blue Shield of Vermont. For the record, I did provide a pretty extensive written testimony last week. I'll start by saying, as you might imagine by that written testimony, we share the concerns regarding QHP of, I think, every single person in this room and well beyond. We have presented the concepts in that written testimony related to a study on the QHP. And I know that that's a terrible, awful word to say, except that everything in the piece that I submitted to this committee last week has been talked about in separate studies this session. We've talked about silver loading this week. We've talked about age rating this session, out-of-pocket maximums, and on down the list. And there's a reality in the QHP that the regulatory nature of it and the mechanisms within it contribute to some of the expense. And we would very much like to play a role in fixing that. And I think we made that clear in our written testimony. So beyond that, we've heard this committee, we've heard all of our regulators say very clearly, bring us some more options that are more affordable for the QHP. We're on our 3rd regulator with those new plans and have still not got them approved. So we're trying in the QHP. I would say we were a little surprised when we saw this bill in the Senate. And then when we heard testimony from the Care Board, who I should say we trust explicitly to carry out this work, that they wouldn't be going any further in this upcoming hospital fiscal year, given Act 68 and the implementation requirements, given some of the other conversations and successes of Act 55. We did present a proposal to the Care Board in October on the high costs and high prices of labs and radiology. We did that to the all-ledge briefing in December. We presented that to the Healthcare Advocate, Vermont Healthcare 911, DFR, the Care Board again, and the Senate. And the reason we did that is because Act 68 explicitly calls out that the Care Board will reduce prices on items and services. So we found items and services and delivered the ones that were next highest priced after we used reference-based pricing to reduce the prices of items, drugs, using a Medicare rate. And that's all I'll say. I don't particularly have a stance on what the percentage is or what the dollar amount is. We trust the Care Board to do that work. I think Chair Foster and Commissioner Sampson have testified that to something that we agree to. We're in a different place right now than we have been in recent years. I have conversations very frequently with our colleagues in all of these different areas. And I feel really good about the direction that we're heading in. On March 24th, we did send an email to the Care Board informing them that a plan to deliver reference-based pricing solely in the qualified health plan, I think the exact terms we use would be expensive and messy. And we stand by that.
I'm sorry, what? Expensive how? Wait, I'm having a difficulty following your, it would be expensive and messy we're moving towards reference-based pricing across the system.
Right, for items and services.
And it would be expensive and messy to do reference-based pricing for the QHB.
Group, yep.
Why? How?
Because you're doing all of the items and services for certain people in certain places.
If the Green Mountain Care Board, do you change your prices at each individual place across the board every single year? Do you change things?
My testimony is in regards to Act 68 and reference-based pricing, and that it requires the Care Board to deliver a reduction in prices on items and services.
Again, I'm sorry, I'm not asking about Act 68. I'm asking, can you operationalize, if the Green Mountain Care Board said to you, you will not pay hospitals more than 250% of Medicare, and I'm just throwing that number out there, don't get excited about the number. You're saying that even though every single year you change all your allowed amounts for every individual provider, facility, hospital, you're saying that it would be difficult to operationalize?
Didn't say it would be difficult.
You just
I said it would be messy and expensive. I didn't say it would be difficult.
Messy and expensive, but not difficult.
Right.
Would the board like to?
I would just, so I was going to refer to the email that was sent to the board on, I think it was March 24th. So this email was from Rebecca Knights, the general counsel. She said, this is an expensive and messy policy direction. However, if this is the direction the state feels is the best solution for Vermont, we are prepared to move forward and implement it in line with the target dates.
Correct.
And that's referring to.
I don't think I said anything to the contrary.
That's referring to 190.
No, I don't think you indicated that we would be ready to move forward and we would do it.
Okay.
To which is
correct.
Yes. Okay.
I mean, if it's a law, I don't think we have a choice.
Any other questions?
I think the last thing that I might suggest, just relative to reference-based pricing, and I'll just reiterate that we have no reason to question what the Care Board is going to do on implementation. We actually feel very comfortable with the direction that they're heading. That's why I'm not sitting here saying, do labs at this percent and radiology at this percent. We're very happy with the direction and the decisions. I would say, There may be unintended consequences with specialty groups, and what those are, I don't know. I'm not a regulator. It's not my job to decide what those are. And it wouldn't be in the best interest of this process to lay out hypotheticals or what ifs.
Brian, did you have a question? Did I hear
I
you?
do. I did, and then I said sorry because I was interrupting. So you said it would be messy and expensive. What I'm wondering is, if you compare the cost versus benefit between the choice of either waiting for the Green Mountain Care Board to come forward with their plan for reference-based pricing for everyone, or taking action now to test out how to start extending it to people. If you weigh the cost versus benefits of those two choices, which one do you think would be a better deal for the greater good?
Oh, great question. I'll just reiterate what I said last week in testimony, that there's no possible universe in which I would sit here and say, no, please don't save anybody any money this year. People need savings and they need it this year. Our mission, I will go back to this every time you have me here. Our mission and our statutory obligation is to all Vermonters, not just the QHP, not just VHI, not just the state of Vermont. It is to all Vermonters. And we've been reminded of that several times in this committee, this session.
Karen, and then we're going to move on to Deb.
Would implementing reference-based pricing, however it's delineated at this time, end up with lower premiums for those that are?
Oh, in the QHP?
For
Definitely.
example, let's just say.
Yeah, under what's written right now in version 1.1, 100%. I mean, not 100% less premiums, but 100% yes. Yes. Yeah, 100% yes. It will deliver lower premiums for people in the individual and small group markets.
And in the VHI.
And VHI, yes.
And I was going to say, and in the VHI?
Yeah, yeah.
And we heard, some testimony that, or information from Commissioner Sampson about that there's a difference. Do we have any sense of the percentage of reduction in premiums?
We can get a percentage very quickly as soon as we see a dollar amount or percent of Medicare from the Care Board.
Thank you, Courtney.
Yeah, you're welcome.
Kevin, already up. Getting in order.
Good morning, Devin Green, Vermont Association of Hospitals and Health Systems. Thanks for having me in today. I'll just dive right into S190. But actually before I do that, I do want to correct the record. Chair Foster is right. Our report did say 140 million. I was thinking 100 million operational costs and 40 million transformation savings, and I had those separated in my mind. So correcting the record on that. Section 1. I just want to point out that this is a piece that requires hospitals and health insurers to report their prices as a percentage of Medicare. The Medicare defined later in the bill is different than the Medicare base defined here. We are worried that we would be reporting sort of non-transparently by doing this, reporting a percentage based on what we receive versus what the Green Mountain Care Board is planning to do. We think it's administratively burdensome. I'm not sure what it's trying to achieve. And so we would ask to take out the first part, but keep in.
Can you give us page?
Page 1. Okay.
Yes.
Section 1, it's a requirement that all hospitals and insurers report their prices as a percentage of Medicare. Then it has hospitals reporting what they receive from Medicare, their reimbursement from Medicare, as the base to go off of with a percentage. We asked for that because critical access hospitals can't figure out, they can't convert their prices to community hospital prices, PPS hospital prices. But looking at this further, the Green Mountain Care Board's going further. It's going forward with reference-based pricing, like now-ish. I'm not sure what it achieves to have hospitals report on something that the Green Mountain Care Board is not going to use as its base.
What is the base?
Hold on. So just so I'm following like the trajectory here. You asked for this language, but now based upon the other, it doesn't make sense. But it was for the critical access hospitals, and the critical access hospitals are exempted
They'll still have to do this.
reference-based pricing.
They are exempted from the reference-based pricing. They would still have to do this reporting. I am okay with reporting. I just want it done in a uniform way that's not administratively burdensome. So if the Act 68 gave the Green Mountain Care Board the authority to get all of our contracts, to get our prices, great. We are happy to provide that information and those prices to the Green Mountain Care Board. But we don't, the methodology, it would be good to have a standard methodology for all this. We will post whatever the Green Mountain Care Board wants us to post on our website, but to have each hospital do the calculation, I think just sets us up for non-standardization. And I'm not totally sure what it's going to be used for when actual reference-based pricing is going to be off of a different base. So I'm happy to have express it as express our
Line, what page, what?
page 2, when it said, the collaborative process.
So
So,
what line?
line 5.
In the interest of time.
Yeah.
Would the committee be okay with me working offline with Vaz and the Green Mountain Care Board to, I don't mean to say this, understand.
Yes.
Understand.
Help us
Yes.
understand.
Yeah, that would be great.
And see what see what the problem is, instead of us sitting around here trying to
Yes.
understand.
Perfect.
Sounds good. Yes.
Happy to do that. Thank you.
Perfect.
So I went.
Oh, well.
Overlap.
So
Like today, like today.
I was hoping you could comment on the
Section
section, no, 11, what is the new section?
Happy to do that. The section that we all hate.
Yeah.
The critical access. Yes, we hate this concept. I cannot say enough that we hate what the federal government does.
We're going to say you hate the section, because we all don't hate the section.
We hate the policy that the federal government has applied to critical access hospitals. We all hate the problem. I agree with that.
About that.
Yes, this was put into law so hundreds of critical access hospitals closed hundreds of hospitals closed across the nation in the late 90s. And that was because, I'm not going to get into a rabbit hole now.
Just a brief.
In response to all those hospital closures in rural areas, critical access hospitals were made. They were designated. A different payment was given to them to keep them open. It was a response that said, we realize that access is really critical in rural areas. And so we are going to pay you specially just to keep you open. And then they had this cost sharing piece that's been in there from the very beginning. And I think it's to save the federal government money.
So we're gonna save you by paying you less.
No, it's the federal government money.
Also, it was not quite as egregious when hospital prices were actually.
Oh, okay.
in the realm of,
So it's diverged.
normal.
Fine last
Yes.
and it's nothing now.
So in section 11, our concerns there are both through budget orders and through this language, putting a solution into state law. We're very worried about federal compliance issues around this. The federal compliance issues we're worried about are critical access hospital payment requirements that no Medicare costs be borne by other patients and no other patient costs be borne by Medicare, uniform charge requirement, Medicare cost apportionment, bad debt requirements, and anti-kickback statutes. So we have concerns in the compliance space with the federal government. We don't want to be between a rock and a hard place when it comes to state law telling us to do one thing and federal law telling us to do another thing. We are very happy to continue working with the Green Mountain Care Board on this, and we have multiple hospitals that are interested in doing a pilot program to work with our local insurers to figure out a way to make this work.
Which
I just want to say, this section, none of the, I understand that the solutions that are in the stakeholders that are being discussed, that you have concerns about like going in federal law and all of that. That's not what this section is saying. This section is just simply saying.
Change your charges.
No, what it's saying is, can you identify the outliers
Okay.
and just lower
Those.
lower your price so that it's no longer the outlier to 5 times.
I understand that and agree that that sounds very reasonable. And that may be where we end up. Just don't put it in the law so that in case that's illegal, we're not violating the law.
For 2020, so I think we're gonna need to get some clarification on that.
the legality.
Yes.
We're happy to submit a memo on that.
One second, Brian.
Um,
Karen, did you have a question?
Well, I just want to understand, and I don't want to take much time with this. At 500%, that is what it costs. That's what Medicare would be obligated to pay. So why would you be, and maybe that's what this memo would do. Well, I don't understand why you're gonna.
so we're concerned about the compliance issues, right?
Yeah.
We have specific, like people have said multiple times in testimony, we want federal dollars back into the state. The federal government may not take too kindly on that. The second piece is there's a lag time that's based off of our charges, the sort of cost reimbursement piece. So we would have 1 or 2 years of lag time where reducing those charges would leave us with less money from Medicare. And we're not sure how we can make that up when things are really tight right now. And then the third thing is changing our charges, changes our commercial rates, and we have no idea what the impact is of that.
Okay, so just putting that complexity aside, and I'll let you do the memo. What about the informed consent to the person?
Yes, happy to do that. We're working on a template right now to give to all our hospitals. We want to direct them to Medicare shared savings programs. We are happy to do that work. Yeah.
Do you agree with Chair Foster's point that when Medicare beneficiaries learn about what is happening to them, that they are going to vote with their feet, and that will actually hurt critical access hospitals more than just tapping 5 times what Medicare allows?
We don't know. We don't know the answer to that
The
question,
exact same amount of money.
not from commercial insurers, and we don't know the answer to that question.
And so this section just simply asks you, what if we took out that you had to lower it, but that for the next year you at least identify? Because you did just say,
Yeah.
well, we don't know what it would be because we don't know.
Right. Happy to do the identify. Yes, happy to do that.
Right.
Yeah.
Line are we on there?
I don't know, but I have a couple more things I just want to get in before. I get the-
Now go. I'm gonna wait.
I think we can probably go 5 minutes over.
Okay. Definition of hospital in section 2. Thank you for excluding critical access hospitals. I think that's helpful in implementing all of this. The one ask that I would have is to also exclude a Medicare dependent hospital / rural community hospital. That's Brattleboro Memorial Hospital. They function much like a critical access hospital, and we would have concerns there about them. And then the other piece I would ask is that when we talk about 2.5% hospital spend, we don't have a definition for that. I would propose that the definition be the commercial net patient services revenue.
What page you on? Language, you get out of 68 to 2.5%.
Of hospital spend, it's intent language.
I mean, it was in, if you want to be collecting the tests or something.
We would just, now that it is gonna be law, like, and more than intent language, we would want the definition to be clarified to commercial net patient revenue. And we also agree with the Green Mountain Care Board about taking out on page 5, line 11, that's the part 2. I hear what you're saying in terms of trying to do this to ensure that things move forward, but I think it creates further instability to have both the reference-based pricing process that's being done incrementally and then this added onto it. I don't know how it works in that space.
Brian, did you have a question?
I'm confused, but I think that we're rushing you and that's part of it. And then and so instead of trying to ask questions and holding us up, I'll let the chair and you talk and then see what comes out of that.
Okay.
I wait, there is this one thing,
Okay, yeah.
which you can answer with the chair, you can figure out later. When it comes to the Medicare part.
Yeah.
This, because now I'm confused what part is what that you were talking about, because it was going fast. One thing I would just ask in general is that everyone look at what other states are doing in these areas and what they're already allowed to do, because if other states are doing things already, like having a working group to look at how to
We're not
match.
doing anything on this.
So no state has looked at how to
No.
address that issue. Okay, that is helpful to know. And what I'm hearing is you already checked into that.
Yes.
Yeah, thank you.
Okay, so to level set the table, first of all, I'm sorry, healthcare advocate, for bumping you again. Till tomorrow.
Will you start?
Yes.
Excellent
And throughout the day today, because we are going to be on the floor all day today.
Oh, no.
Throughout the day today, if I could intermittently meet to address some of these concerns, and maybe if Ledge Council would be there, and we can talk through some of these concerns, and then we'll end tomorrow morning with
Chair, can I say one thing?
yeah, you can. You may.
I submitted language that appears on your webpage on Tuesday. And I would like an opportunity to speak to it. But I did want to at least.
You have 5 minutes. Would you like to go?
Right?
Healthcare advocate.
Talk about efficiency in government.
Just to finish the thought, legislative intent language. I don't know if I have 5 minutes to actually do this, but let me just. So this feels important to me. You had a parade of people come before you that said, do this in 27 or do that in 27. I would add myself to that list. I do have opinions about what should be done in 27. But I think more important than what happens in 27 is that we set the goalposts of where we're going. And we are not doing reference-based pricing just for the sake of doing reference-based pricing. We're actually trying to do something here. And so I put this language here. My dodge about what actually happens in 27, there's a lot of pitfalls in this. Are we really doing provider rate setting or are we doing insurer rate setting? That's a big deal. I care a lot about that. Are we doing the whole market? Are we doing segments? Are we doing all hospitals or doing segments? I care a lot about all that stuff, but with clear legislative intent language about where we're trying to go, it feels easier for me because I think there's clear legislative intent about the direction. So I have talked to the board who has expressed support for this. I don't know if you're, and I've talked to Vaz who's expressed support for this, and I've talked to Blue Cross who's expressed support for this. So there's a great deal of consensus about adding this language or something like it. I want to add, I too am concerned about the section 2 on page 5. It was talked about verbally in here as being for 2028, and I think the words on the page say for years after 27. And so if it's really intended to be for 28, it should say that. And I am also S190 was designed to do a lot of things, but also to define this tangible step that the legislature directed the board to do in 27. I want to depend on the board and the rulemaking process that they're going to do for years 28 and beyond. And so that's a principle of mine that feels important. So I am opposed to that section 2 because I think it is a distraction. And because, like I say, I can get over all kinds of things in 2027 because it's 1 year, but I think that language extends the concept of doing insurer rate setting instead of provider rate setting beyond 27. So I'm happy to work on details on how to massage the language to have it say exactly what we want, what you want it to say, maybe closer to what I wanted to say. But I think the main thing I want to offer is I would hope that the committee could join me in supporting this concept.
I will just say, I fully support this concept. And it sort of, in a way, Colin, you were talking about, the report of saving, well, one thing we never actually did in Act 68 was just because you say you're doing reference-based pricing, that doesn't mean you're saving anything. You can set the reference anywhere you want. You could set it too high, and we never put a goal of actually getting to something. So what difference does the reference-based price make if you don't know where you're going? Thank you for bringing that language forward. And we have 1 minute.
Yeah, if you can always tell us when you come back, if there's not time to really answer this now, but you provided, I want to thank you for this useful testimony on one part of the bill. There's another part that you didn't talk about.
There's like 20 parts I didn't talk about.
Okay, well, whatever. There's another part that you didn't talk about that I want to ask you about. That's what I'm trying to say. We heard, you were here, I'm assuming, and heard the testimony I heard about the piece around setting that, changing, I'm trying to say this in a way that's not biased. So changing the collective bargaining process in an attempt to save collective cost on healthcare, maybe. As the healthcare advocate, do you have any thoughts about how that erosion of workers' rights to temporarily save costs while we're trying to implement reference-based pricing for everyone, how that might impact public health, impact workers, impact patients?
I am going to significantly dodge.
Okay.
As the healthcare advocate, it's outside my lane.
Okay.
As Mike Fisher, I have strong opinions, but I'm not here as Mike Fisher. Though I will say this is an important bill. The reference-based pricing section and other sections are, I think, important bills to get over the line this year. And I fear that the other section, the section you referenced, is a significant distraction and will make passage hard.
I won't vote yes for it within a minute. I'll tell you that right now. So.
Thank you. We'll see you tomorrow, bright and early. The committee, please keep up with, because we might be meeting early tomorrow.
What is early, like 7?
Maybe 8:30.
There's a meeting at 8 to 9 that I'm obligated to.
Okay, maybe.
Jump on Zoom at 8:30 with me.
Maybe we'll be meeting at 9 then. Okay. And we will
I will be there on
probably
Zoom.
also be going long tomorrow. We have 2 bills to get out, and frankly, we haven't even started marking up one of them.
Yeah. And what is long, like 5 or like 9 at night? We could order pizza.
We'll be here relatively late, I think. Friday, sorry. We can go off live.
You mean past 5 though?